So 1 minute, and then we are ready to start Rumble. Hello, Ms. Gruber. Nice to see you. So I think we can already start. Welcome to the next session of LDE. My name is Thomas Hoeren. I want to teach you and love to educate you in LDE. We have spoken last week in the Q&A session about the intermediate test in February. You have the date, you have the structure. It's an open book exam which finishes the winter term. I only want to say that the students from Münster who are here in this group, who are listening to us, who want to have that exam accepted as Schwerpunktklausur for their studies, they have to contact us, because you are not allowed to take the open book exam for the Prüfungsamt of our faculty. So you have to contact the researcher of our institute who are here. For instance, you see Nora Fuchs, she is listening to us and ask, what do we have to do? Are there any questions left from the last Q&A session? Never hesitate to ask questions, because of course I'm here for answering your questions. So the structure, only for avoiding that you are losing context with the structure of the course, we have started with the famous sentence, information wants to be free, and have seen that information rights, so exclusive rights in information, can only be guaranteed if there are special justifications. We have found one justification, trade secrets. Then we have seen a large sections on copyright law, including copyright for AI products, difficult topic. Now we are leaving intellectual property rights and talk about unfair trade law. The unfair trade law is a very, very strange topic, because we have totally different traditions. I will tell you in my slides. If you compare Germany, France, and UK. So nobody knows, and it's changing every day. Is there really an unfair trade law, or is it only a mixture of data protection law, consumer protection? Is there really a feeling of having unfair trade, especially in the internet? So I will start with my slides. To justify myself, I had to change the slides very often, because we had last week the unique chance to see the Digital Omnibus. There is a new plan of the Commission to change the whole structure of information law in Europe. So I have to adapt my slides to Digital Omnibus. What the Digital Omnibus exactly is, I will explain you later. So these are my slides. We have a strange topic, UWG, international. UWG is a term from Germany. It's an act on unfair trade law, but we are not talking about German law only, but about international unfair trade. Why is it an international topic? We have a very old convention, the Paris Convention from the 19th century for the protection of industrial property. It protects patent, trademark, industrial design, and as well the repression of unfair competition. This is the first time that the topic was dealt with in international regulations. There's Article 10.2, it's written 2TO, that prohibits for all countries of the Union to that competitors deal with any act of competition contrary to honest practices. That's a strange term, honest practices. What is an honest practice? And in particular, this provision prohibits all acts which have to do with creating confusion. It's not restricted to business to consumer. It's also applicable to business. No, avoid confusion in trade. Avoid false allegations in the course of trade, and avoid indications or allegations that are misleading the public. And then you have Article 10, third article of Article 10, which prohibits, which says you have to enforce in the national law, you have to find legal remedies for fighting against unfair trade. Especially, you have to provide remedies for federations and associations representing industry and consumers. So let us have a look at what other countries are doing. For instance, we have China. In China, they have an act on consumer protection. I will talk about that next lecture. But they have, for instance, interim rules on unfair trade in AI. So these rules are only made for the purpose of avoiding that AI providers make their software available to the domestic public. So China is only afraid of causing political disturbances in the internet. That's the main issue. You can do whatever you want, but when the content is considered politically harmful, no matter, that has to be stopped. So that's a typical Chinese approach. Then take the USA. They have, of course, as well an unfair trade regulation, which is a topic of next lecture, but they have special rules on Algorithmic Accountability Act that is made for increasing the level of transparency and accountability of companies using AI systems. So they even started in doing it in 2019, very early. So the Act defines AI as computerized processes that make decisions or support human decision-making and affect consumers. That is very important because that is one model which later leads to EU regulations. These AI organizations must conduct impact assessments. So you have to provide a paper saying what is the impact of your AI systems and of all high-risk information systems. And all is enforced by the help of the Federal Trade Commission in USA. So let us come to Europe. We have primary law and secondary EU law. I hope you have seen our video. We have made a special video if you're coming from a country which doesn't belong to the EU. because then you don't understand what's the distinction between primary law and secondary law. Primary law is the Amsterdam Treaty, the foundation, the fundamental treaty of Europe. Secondary law are all the acts, directives, regulations made within the EU Parliament and Commission. The primary law says you can do whatever you want, but you have to stick to three main principles. That is free movement of goods. So goods want to be free and are protected for a wide, free circulation within Europe. You can prohibit as a member state quantitative restrictions, and you can involve measures having equivalent effects. That's an important word. But these restrictions need to be measured according to the fundamental freedom of movement of goods. So there's a balanced test of free movement of goods versus national laws having equivalent effect compared to quantitative restrictions. That has led to the ECJ to prohibit sometimes national laws on unfair trade law. The same involves with freedom of establishment. So all restrictions on the freedom of establishment is prohibited unless justified within the balance test if it is necessary for a higher purpose, then you are correct. But unless you don't find a higher purpose, it's forbidden. And the free movement of services. Based on these three fundamental freedoms, we have secondary community law. I don't want to mention all of these directives and regulations. For you to understand, directives are a second best solution, because directives are only binding for the member states, which have to implement these directives in their national laws. So they have a chance to say, we will implement a directive in a specific Greece or a specific French way. So there's a freedom for the national states to decide upon the way of implementing. That is a directive. If we have a regulation, that is first solution, then the Commission says in the Parliament, this is automatically binding for every EU citizen. There's no need to implement a regulation. You see the difference. We have directives on misleading advertisement, very important. We have a directive on e-commerce. We'll talk about that in 50 minutes. Then we have a directive on unfair commercial practices, so-called UCP or UCDP directive. Then we have a directive on misleading advertisement and so on. Apart from that, we have certain regulations in the area where it's absolutely mandatory to have European law. There you see one example, very important regulation, not directive. So it has to do with internet. The P2B regulation, platform to business. So it has to do with platforms doing business for business people. That is, for instance, Google as a platform for involving traders. Let us talk about that P2B regulations. As a regulation on promoting fairness and transparency for business users of online intermediate mediation services, which entered into force in 2020. There you see the nice symbols who is involved: Google, Facebook, Amazon, eBay. These are typical online intermediate services, or online search engines are also a part of these P2B regulations. This regulation is only applicable if you have 2 times market locations, because it's only applicable if the service or search engine is offered to a commercial user based in the EU, and the commercial user himself is offering goods and services to consumers residing in the EU. So it's double principle of market location in Europe. There's a list of companies who are not part of P2B. I won't talk about that, but only to say that's very important, even from a historical point, because it involves certain measures which you find in the Data Act and the AI Act as well. So Google or Amazon has to disclose ranking parameters. It has to draft general terms and conditions. It has to provide an internal compliant management system. It's not allowed to use self-preferencing tools. So to say, we are the best, you have to give us the best prices, and it's not allowed. And access to data, certain data are free to be used by the commercial users. So, for instance, to say that about Article 5, if it comes to the disclosure of ranking parameters, the providers are obliged to disclose the most important ranking parameters in order for the users to understand how the goods and services offered are highlighted. So, in the mentioned Articles 3 and 7, you have to draft general terms, and you have to publish them. And there's a certain minimum standard for these general terms. They have to be clear and comprehensible. They have to explain under which of the provision you can restrict certain commercial users. You have to inform about the distribution channels. You have to include in the terms certain provisions on the restriction and how you can complain about restriction when it comes to Google or Facebook. And access to data, providers have to disclose technical and contractual access to data in their terms and conditions. So that is perhaps enough for the P2B regulation. As I said, you will find the traces of the P2B platform regulation in the AI Act, in the DSA, and in Data Act. Another regulation I want to talk about is, in fact, a directive, the famous directive concerning unfair business to consumer commercial practices in the internal market, the UCPD directive, which is today very often applied by national courts in order to restrict business practices. The aim is to harmonize the rules on unfair commercial practices in the relations between business and consumer, not B2B. So it's a fully harmonizing directive. That's a very difficult distinction. You have certain directives which claim to be fully harmonizing, and you have certain directive which leaves the door open, expressly open for the national states to make different rules. So the UCPD directive is fully harmonizing, meaning that no derogations, even in favor of the consumer, is possible. We are not allowed to create new German rules for protecting German consumers in a better way. The aim is to strengthen consumer confidence and cross-border trade. It covers a wide range of practices, including the provision on inaccurate information and the use of aggressive marketing techniques. It was amended several times, and very famous is one thing, as first the key provisions. There's a general clause saying that commercial practice doesn't have to be unfair. There's a definition of what is unfair and what is misleading. So the directive is speaking about honest practices, about a fair approach, and important is the Annex 1. That's a blacklist which contains a lot of practices which are regarded as forbidden. So if you are in the blacklist of Annex 1, you are lost in hell. So in Germany, you might perhaps know that the Annex 1 is part of our UWG. There was an annex in our Unfair Trade Act, which says certain practices are forbidden per se. So there are two examples about former directives and former regulations. The last attempt the Commission's made and prepared is the DSA, the Digital Services Act, which is very, very important. We will talk about the DSA quite often. Today, I'm mostly interested in Article 25 to Article 28, because there are three regulations, 5, 26, 37, 4 regulations which are directly enforced by a regulation on unfair trade law. So Article 25 has a famous prohibition of dark patterns. That's a very fashionable word. If you want to kill a person, you simply say, you are using dark patterns in your advertisement in the internet. What does dark pattern mean? Providers of online platforms shall not design, organize, or operate their online interface in such a way that users are deceived, manipulated, or otherwise significantly impaired or hindered in their ability to make free and informed decisions. Wow, that's a really broad regulation. What is meant with ability to make a free and informed decision? That's a very important question. And who is meant as a user? Is it a man who has a university degree and knows everything about internet? Or is it a poor farmer in Germany who has never made a real exam in school. So what is the standard for saying you are hindering significantly somebody in his ability to make free and informed decisions? Nobody knows. Then we have Article 26, which says information, information, information. So you have to inform people. You remember my wording from the United States. That's an invention of the United States. If you say nobody is allowed to restrict users in the ability to make free and informed decisions, then you have to inform people in a clear, precise, and unambiguous manner in real time. But a lot of circumstances, as more explained in Article subsection 2, you have to offer a service, a function for which we can declare whether the content constitutes commercial communications. He has to ensure that all users can establish clearly and unambiguously in real time the information about the commercial communication and so on. Then you have subsection 3 saying that targeted advertising on online platform is prohibited when the profiling uses special categories of personal data, such as ethnicity, particular views, sexual orientation. This is mostly prohibited to use that as a tool for online advertisement. So we don't have only the DSA, but we have a certain amendment in the EU AI regulation. The Commission has made an AI Act, a regulation which is immediately binding for every citizen within Europe. This AI Act bans, for instance, manipulative systems. So to build up a system which indirectly manipulates others is prohibited. You have to stick to the labeling. There are certain labels which an AI provider has to use. You have a transparency and disclosure requirement. So, let's see better. And let's talk about dark patterns. Even dark patterns are expressly prohibited by the AI Act. So we have two provisions of dark patterns in the DSA and in the AI Act. We have even a third provision in the Unfair Commercial Practices Directive, ECDP. So dark patterns are prohibited by 3 regulations at least. In the past, in 2019, the ECJ has already decided upon a case which has to do with a kind of dark pattern. There were, in that case, 3 ticket checkboxes. So you come to a website, and there is a certain buttons already clicked on by the provider, and you have to stop the click on in order to avoid closing contacts. There's a clear violation of dark pattern. The ECJ in that case, of course, only regarded the UTP, because at that time nobody was talking about DSA and the AI Act. There's a recent case from 2025 of the Higher Regional Court of Bamberg, wherever Bamberg is. A similar case, there was an event ticketing platform which used pre-ticket windows. There, the court held the claimant cannot rely on the DSA because the DSA expressly said if the case has to do with the UCDP, then you are not allowed to rely on the DSA. So the question is, we have 3 prohibitions of dark patterns, and which one can we apply? The DSA, the AI Act, or the UCPD? And the Court of Bamberg says it's a question for UCDP, and UCDP is ruled in Germany by the German UWG. But we have colleagues in that cause from the Netherlands. The Amsterdam court says differently. If Meta, Facebook, is using a secret algorithm to check whether somebody is rich or poor, that is as well a dark pattern, and they applied Article 25 of the DSA. So the first time we have a case in October from Amsterdam, from a Dutch court, where directly Article 25 is enforced. So that's all I want to say. And let me make a last reference to EU considerations. There's a beginning discussion on the Digital Fairness Act. The Commission is planning for next year a next act called the Digital Fairness Act. They have made research and a long expertise. What are the typical unfair behaviors in the internet? Of course, dark patterns, addictive design that particularly affects usage time, opaque price structures, unfair personalization. That's a very, very important topic called dynamic pricing. You see, as somebody wants to ask a question, no, I don't see there's a hand on in my slide. No. What is dynamic pricing? AI leads to a situation where you can say, this is a high price for people who are living in Munich, because people living in Munich are normally rich. They can afford to pay the high prices. And if you're selling a product to people in Ostfriesland, they are very poor people, you're saying, oh, and I need to have different prices for people in Ostfriesland. And you can even say, I will trace back the consumer and build up a personal profile. And because I have so many information about this person, I will use that information for making different prices if you are Thomas Hoeren or if you are Matthias Rosa. That is possible. But that is regarded by the Commission as one of the strangest elements and particularly unfair. You see what is planned. We have public consultation, which was finished on 9th of October. And next you will see the rising of a Digital Fairness Act in Brussels. So, stop, have a break, and we are going to the rules. We have special rules, and we have the general unfair trade law. So we have general rules saying it's forbidden to act unfair or aggressive. But we have to check in advance the special rules, because the special rules are special. Special rules are there for the protection of minors, for product-specific special rules, for special rules for a certain profession, doctors, lawyers, and we have special rules for certain marketing tools, for instance, cookies and spams. Let us first talk about minors. Again, this is a topic for the DSA, the Digital Services Act. In Article 28, it's provided that providers have to ensure a high level of privacy, security, and protection of minors. When you've seen the discussion of the last weeks in Germany, you know that a lot of people are now thinking of improving the situation of minors who are misusing TikTok and Instagram, all these things. It's a very broad rule in 28. Providers shall put in place appropriate and appropriateness measures to ensure a high level of privacy, safety of minors. So you have to implement protection measures called age verification. I will come to that in a minute. You have to apply advertising restrictions so that nobody who's under 18 can use YouPorn, the most seen website for other adults. We have data processing or limitations, time limitations for misusing TikTok for the whole day. So this is not only done in the DSA, but there are code of conducts on age-appropriate design, which are planned and discussed. And the EU Commission is thinking about ways for a good technical age verification system. If you see the situation in United Kingdom, for instance, they already had a children's code for protecting minors using social media. They have a new Online Safety Act, which is active now, and they have certain regulations, code of conduct for talking about children. In the United States, we have the COPPA reform. That's a reform of the Child and Pornography Act, protection and pornography. There's a review planned to better protect children. There are state-level laws, for instance, in Vermont and Nebraska, and there are special acts on the state level, for instance, in New York, Child Data Protection Acts. In the EU for next year, that's a big topic to more focus on the protection of children. So age verification, data minimization means to store not so many data of children and to restrict this uncontrolled use of children's data. We have restrictions, a plan to restrict certain advertising. And of course, there's a big problem in the Digital Fairness Act, the avoidance of manipulative design patterns. So there are a lot of plans, but it's difficult to do that. Let me just talk about the problems. The state supervisory authority, which is organized in Germany on a state Bundesstaat level, so it's a state organization, not a federal organization. Here is a state media authority in North Rhine-Westphalia said we have to stop all these children from seeing all these rubbish YouPorn videos. Because I wonder if anybody of you has seen YouPorn. You are now allowed to use porn for scientific purposes. So if you start YouPorn, it's a free service for seeing thousands of strange videos. You get a website saying, yes, I'm elder than 18, or no, I'm younger than 18, and that's all for age verification. The state media authority in North Rhine-Westphalia said this is not enough, and so we asked all access providers to stop the access to this website. This website are operated, in the case, from Cyprus. People in the state of Cyprus said, we don't take care for YouPorn or online gambling. It's not a matter for us. So can the state supervisory authority demand that access provider blocks access to these websites? They tried to do it, say that in several cases, but last week, the Court of Appeal in the administrative matters said, no, you are not allowed to say that because Cyprus is part of Europe, and within Europe, only the laws of the state can be asked to reinforce where the company has its seat. If the company has a seat in Cyprus, only the Cyprus law of use protection has to be applied. They don't control use protection. And so you cannot say, coming from Germany, I want to stop you to stop the access to that site. It's a matter of European law. As I said above, we have the primary law saying the freedom of providing services is a fundamental right in Europe. So only the rules of that company's of the seat of the company has to be applied, but not the laws of all the other states where you can get access to that site. Another problem, age verification. How it is done technically. I wonder whether you've tried, for instance, to send a bottle of vodka on Amazon. Then you have to verify that you are above 18, and that can be done by the identity card, but minors can steal your identity card. There's a high risk. Is it a GeoPay? Is it post-ident cash card? And no, really 100% secure age verification is known until now. Next topic is talking about special regulations for minors. We have to talk about occupation specific. Perhaps you have a job which has special rules. That's very important for France, for Germany and Austria. We have very harsh rules for doctors, medical people, and lawyers. So, for instance, in Germany, it was only a question with the court whether a doctor can consult his client via video. Can you consult in medical matters via Zoom? Now it is to a certain degree opened by specific rules for medical people. If you see, the EU law is not very easy to regulate that stuff in these kind of code of conduct rules. In the decision voters, and the second is Deutsche Zahnarztportal, the court said you can have rules adopted by professional bodies, but they are subject to EU competition law if they restrict market conduct. And they are only compatible with the Amsterdam Treaty if they pursue legitimate public interest objects and remain proportionate to their aims. So you're not allowed to prohibit medical people, doctors, in a professional code from advertising and consulting in the internet. So, but you see in that decision of the High Court, High Reasoning Court of Karlsruhe, that in Germany as well as in France and Austria, the courts are still unwilling to say you can advertise video consultation via Zoom, because that might infringe national laws governing medical advertising. And then we have our famous advocates, lawyers, who are, from a traditional view, very, very dissatisfied with legal tech. That's it. Legal tech leads to a situation where we are losing money. So they went to courts and said, we will want to prohibit legal tech services. That has been prohibited by the Supreme Court in Netherlands, as well by the Federal Court, has been as well allowed by the Federal Court of Justice. So Dutch Supreme Court and the German Supreme Court said that is free. So you're allowed to do in legal tech to a certain degree the same as a lawyer and as an advocate. And then we have a special topic, influencers. That is regarded as a miraculous job. Young people earning billions of money were simply saying, I like this thing, this towel, and I can recommend that on YouTube, and they get money for these recommendations. The Federal Court of Justice in Germany has made a lot of decisions on that, And in the influencer 1 decision, is that is influencing advertising in the sense of unfair trade law? Yes, it is advertising if the influencer gets money for a recommendation or if the post has excessively promotional character, whatever that is. So, in the influencer 2 decision, they said if no payment is received and the product reference is merely factual, no advertising label is required. So you are free under these conditions. In the influencer 3 the decision, they said each paid way of collaboration must be labeled clearly by saying as a label, this is advertisement, this is a Anzeige, that has to be said very clear. The same approach applies, for instance, in Italy. There we have the Competition and Consumer Authority. They made a lot of decisions on influencing and said fines has to be paid by influencers for undisclosed paid promotions. And there's a requirements for explicit hashtags like publicità or sponsorizator. So they made decisions emphasizing that ambiguous commercial communication violates the consumer code. The same applies for French courts and the Spanish courts. So it's a solution based on national court decisions, but which is so important that it is applied by most European courts. So then we have special marketing rules. The last section for special rules has to do with specific marketing tools. For instance, spams. You all know spams. You get an email saying, you get 2,000 euro if you are coming to our website. Come very quickly. You don't know us, but we will offer 200 euros if you come. All these unsolicited advertisement via email is prohibited throughout Europe. I haven't found a country where you are allowed to spam. All these spammers are coming from countries like Nigeria, Rwanda. So you need to have affirmative and documented opt-in. The burden of proof lies with the sender. You have to prove that the recipient says, yes, I want to get this advertisement. That means there should be a chance for opt-out, and it has to be free and functional. But nevertheless, the best way, the most important way is opt-in. That means ask the person before you send emails. It will be very expensive if you don't do. You get even punished by criminal law in Austria. Is regulated now in Germany in Section 7 of the German Unfair Competition Act. Sending advertising by email without express consent is unacceptable and will lead to fines. Even if you are sending a one-time spam, only in connection with a sponsorship request, you're asking, please send us money for sponsorship. Even that is spam. You can only do it if you had the express opt-in consent. So that leads to the topic why I changed my slides yesterday. The topic of cookies. Cookies have nothing to do with eating cookies and coffee, but cookies are small files which are stored on your computer when you enter a site, and they are controlling what is your behavior on the internet, which websites do you visit, and so on. The general rule established by the ECJ is quite old. The setting of cookies require the active consent of the internet user. A preset checkbox is therefore not sufficient. So no pre-ticket boxes is only not valid. There are a lot of decisions on cookies. I don't want to talk about all these decisions. The last change in Germany was the idea, which it has a consequence for Europe in Digital Omnibus. The Germans have the idea it is very disturbing for the user to click on and decide whether I like cookies or not. Normally, you don't like cookies, but you have to say no, 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 no. Sometimes it takes you 30 clicks to stop all this cookie nonsense. It's sometimes called the cookie fatigue. And people are tired of clicking against or perhaps in favor of cookies. So the Germans have the idea of establishing a consent management system, for instance, of TÜV. You're one time going to a public authority, say, I in general don't want cookies. And that has to be considered by each provider, one click, and this click decides upon thousands of cookies. That has been entered into force in Germany on the 1st of April, but now that leads exactly to the Digital Omnibus. The Digital Omnibus was a consequence of the criticism of the Commission. The European Commission was harshly criticized because they made so many regulations that nobody is understanding what is in the regulation, and there are overlaps between DMA, DSA, AI Act, and so on. And if you take the AI Act, the regulation which consists of 500 pages at minimum. So Ms. von der Leyen said, perhaps we made a mistake, and simplification and transparency is very important as well. So she said, we want to make all this regulation consistent and to reduce the compliance costs. So they changed the AI Act, plan to change the AI Act, the Data Act, the GDPR, data protection will be changed. We'll talk about that when it comes to the point. But one topic is regulated in the Digital Omnibus, which is cookies. Why? What does that cookies to do with Digital Omnibus? The Commission always was dreaming of having a separate cookie regulation. They called it the e-privacy regulation. But this regulation never entered into force. So at least 10 national governments tried to solve the issue in favor of the e-privacy regulation, but nothing succeeded. So we only have in Europe an e-privacy directive. It's not a regulation, e-privacy directive. So nothing was exactly regulated in the e-privacy directive. The e-privacy directive said you can only do cookies with consent for storing and reading information from a user's device. The e-privacy directive says, as an exception, you don't need a consent if a cookie is technically necessary. If you go to a bank, for instance, they need cookies for knowing who is taking money from a banking account, or if no consent is needed, it is strictly necessary for a service requested by the user. Because it is only a directive, all member states have implemented that directive differently. In Germany, we have a TTDSG. In France, we have special rules, sectoral rules. So the idea was only to give guidance from the European Protection Board and so on, but they are not binding rules. So in the Digital Omnibus, they try to clarify and narrow the scope for consent for cookies and reduce the cookie fatigue or this tiredness of the users in explaining what do they think about cookies. They said consent is the main principle. You need express consent, and exception is only foreseen if a service is strictly necessary. One element which is not mentioned on the slides, the decision of the user for or against a cookie has to be taken into account for a time of 6 months. So you are not allowed as a provider to contact a user within a period of 6 months and again asking, do you want cookies? That's very, very complicated, very technically, high level. So let us wait for the Digital Omnibus. It's not clear how and to what extent will all these regulations come into force, but it's important to see what the Commission is planning. So, more deep 1 second of peace, take a nip of coffee, because we have just finished the special rules before we now talk about the general principles of unfair trade law. So the general principles are regulated by national law, and therefore you have to understand what is the difference between France, Germany, and Great Britain. In France, they have a protection of competitors under tort law, general tort law, and they regard unfair competition in general as a topic for consumer protection, but that's regulated in criminal law. So they don't have a special act for unfair trade. In Germany, we have this Unfair Trade Law Act, UWG, I will explain later. And United Kingdom is very liberal, is a traders nation. They do whatever they want, and we regulate the whole issue by a code of conduct, as it is in soft law. So in France, it's only criminal law regulated in the consumer code. I don't want to explain that too long. My main topic is in Germany is the UWG, Law Against Unfair Competition, quite old, from 1909. It's the protection of consumers as well as protection of competitors and as well as the general public. Through injunctive relief, you can say, I will ask court for injunction if somebody is violating these principles. And before you get an injunctive relief, you should send a warning letter to the violator. Please don't do that anymore. This is unfair. This warning letter can be sent by competitors or by warning association, special association doing it. Let's talk about IPR, private international. When do we have to take care for instance, for this strange German UWG? That's the principle of final market intervention. The law has to be applied according to the market principle. Where do you wish to enter the market on this territory? The law has to be applied. But there is one problem I just mentioned with Cyprus. The famous country of origin principle, it was invented by the e-commerce directive. It's part of European primary law. For advertisement, you have to stick to the rules of the company where the company has its seat. It's not the market principle. So it's the law of the seat of the company. That leads me to one funny case. The District Court of Gießen had to decide one case where a travel agency made a mistake in their advertisement. They have forgotten to say who they are. The Landgericht Gießen, the District Court of Gießen, has to decide, do we apply the final market principle or do we apply the country of origin principle? That depends on the question, is the company, does the company has its seat in the European Union? It was an Egypt travel agency, and the District Court of Gießen said, oh, Egypt is in Europe. Funny thing. I think they have drunk too many red wine. So they said, Egypt is part of Europe, so they only have to apply the unfair trade law in their seat in Egypt. Egypt doesn't know in principle, they have to say who you are, and the whole case was dismissed. Then the Frankfurt Higher Regional Court, the second instance, said Egypt is not within the EU, it's outside of the EU. So we have to apply the principle of final market intervention. That means, what is the market for this Egypt travel agency? If they want to have customers from Germany, they have to stick to the German unfair trade law. Therefore, their whole website was a clear violation of unfair trade law. So, this again, Cyprus, even the ECJ said, if a company has its seat in Cyprus, you cannot stick to German unfair trade law. They are only bound by the law of the seat of company in Cyprus. And another remarkable development, data protection is part of unfair trade law. Because in Austria and in Germany and in France, we have a rule saying that if you are violating a principle which has a market impact, that is also a violation of unfair trade law. So we can apply all the principles from other statutes if they have a market impact and say this is a violation of unfair trade. And the ECJ in that famous decision said data protection might be a matter for unfair trade if you are using a marketing campaign and violate data protection rules, you are also violating unfair trade law. So you have the biggest supervision, the most powerful supervision in the area of data protection, the competitor. The competitor has a chance to control the use of data protection rules by his opponent. So let me then show you certain cases. I can mention even 100 cases in the area of internet and unfair competition, but I have selected a few cases, like for instance that one. Take paid customer reviews. You want to buy a Christmas gift, you go into Amazon, and imagine that Amazon or the trader in Amazon is paying 30 euros for each customer who's writing a positive review on Amazon. You're looking at the Amazon website saying, wow, this company has got very nice reviews. It must be a good product. There's a clear violation of unfair trade law. Take that example. Guarantees. You're selling a product and saying, this has a 10 years guarantee. This pullover, at mine, it will never be broken, never be destroyed within 10 years. Again, the higher court says this is a clear violation of everything what an informed, attentive, and reasonable consumer believes. Is misleading because no pullover can last for 10 years. Skip that. Even to a case of the Federal Court of Justice, which was not a violation. So it was a trader used an average star rating. You could see stars beside the website. So 5 stars, 4 stars, and so on. So he always get 5 stars. Said, oh, I have a nice website, nice product, it has all 5 stars. But he doesn't explain what is an average star rating. How many people decide upon 5 stars and 4 stars? Of course, that looks like a misleading advertisement, but the court said this is too far. So the average informed consumer knows that 5 stars doesn't not mean that he only gets 5 stars, and that other reviews are impossible. Or to selling a book completely free of charge is of course misleading. If you have shipping costs of €6, this is a misleading price advertisement. Very important countdown timer. My wife always makes mistakes. You go to Amazon, you see there is only 1 book left. Be quick, buy the book, because otherwise you don't get it. A countdown timer is misleading if nothing changed. It was a system in the Netherlands, same price, continued, and a new timer started. So forbidden. This is especially important in this week, Black Friday, Black Week. So you fake urgency by having a countdown timer. This is again misleading commercial practice within the UCPD combined with Section 5 of the German UWG. The same applies for Sweden, and to mention that. A plumber who is not a plumber is also misleading. It's a joke. Of course, you have the same problem in AI. If you take typical unfair terms relation, the false and inaccurate advertising information from a chatbot, so the answers for a language model may be incorrect or at least inaccurate, and therefore be misleading. If a chatbot is given an answer and doesn't say it is advertisement, that is also misleading and forbidden. And if you don't say to the customer, I use AI as a source, and so again, misleading. So it's forbidden under the UCDP in combination with Section 5. If you say we use AI, but you don't do it, it's again false advertisement. You don't lie to the customers. I have one problem. That's the reason why I'm here in Florence. I'm doing a research study on the question, how does the AI Act lead to consequences under the Unfair Trade Act? Can we say, like in data protection, that any violation of the AI Act is a violation of unfair trade rules? That is an open question, it needs to be discussed, even for other paragraphs in the Federal Civil Act. So, don't want to see that. So that's all some examples of misleading advertisement. let me summarize. Throughout Europe, checked for all the European courts, of course not including Cyprus, but all major courts in major European states have regularly identified the following as misleading. Hidden fees revealed only at checkout is really a catastrophe. Unclear pricing from zone to zone. How do you calculate pricing? That should be open. Misleading discount claims. You were saying, oh, you get the special price. It's only here for today, 20%. It's only a fake reduction. That is misleading. As I said, countdown timer should not link to real price changes are forbidden. Pre-select paid options. Pre-select is always misleading advertisement. And summarize another thing, most national courts apply the UCPD in relation to national unfair competition law. We only have the Dutch Meta case, which is a clear rule saying we will apply directly Article 25 of the DSA. The Commission will probably deal with the following matters: fake urgency, switch back patterns. In the Digital Fairness Act that will come next year. And this finishes my remarks on unfair trade law. Of course, if you are a specialist in unfair trade law, you will say, oh no, this was too harsh. Thomas has forgotten that. But it's only giving you a survey on what is meant with unfair trade. Although I regret that unfair trade concept are mixing with data protection, with consumer protection. So it's getting more and more a mixture of rules and not a clear division that we had in the past. Do you want to ask any questions? No, I don't see any questions. Next week, we are talking about general principles of e-contracting. There's a funny lecture because then you get a feeling for your first semester in law at the university. What is an electronic will? What is offer? What is acceptance? Because that is a very nice topic. And in second weeks, we are beginning with special digital products and their contracting. We are talking about software contract, data contracts, and AI contract. So, if you are satisfied, perhaps you can give me a nice click on even on YouTube. I'm an influencer. I like to be clicked on YouTube as well. So have a nice day.
Thank you, sir. Thank you. Bye.
Bye.
Thank you very much.
Goodbye.
Thank you.
Thank you.